First of all, welcome to today's webinar on climate laws. My name is Ciara Brennan. I'm a lecturer in law at Newcastle University and I'm the director of the Environmental Justice Network Ireland, EJNI. The webinar today is co-hosted by three organisations, Climate Case Ireland, Friends of the Earth NI and EJNI. To find out more about the work of these organisations, please take a look at our websites, and I'll also put some contact details in the chat function at the bottom of the screen. So today we are joined for the webinar by speakers who have each played a key role in the development of laws related to climate change on both sides of the border in Ireland and at EU level. I'd like to take this opportunity to recognise and congratulate each of our speakers on their personal impact on these processes and to thank them for joining us today to speak about their experiences. We will hear first from Anurag Deb, who will tell us about the development of the Climate Bill NI. Anurag is undertaking a PhD at Queen's University Belfast and is paralegal at KRW Law LLP. He was the chief draftsperson of the Climate Bill NI. We'll then hear from Dr. Andrew Jackson on the latest developments surrounding the Republic of Ireland's Climate Bill. Andrew is Assistant Professor of Environmental Law at UCD and a practicing lawyer. He also acted for Friends of the Irish Environment, a successful litigant in Climate Case Ireland, before the Supreme Court of Ireland in 2020, and has played a key role in the scrutiny and analysis of Ireland's Climate Bill as it's gone through the various legislative processes. Our final speaker is Sharon Turner, an established member of the Climate and Environmental Law and Governance community in Europe of over 30 years standing, whose career has spanned senior appointments within the academic, civil society, philanthropic and public sectors. Sharon is now a self-employed consultant, providing strategic advice to climate philanthropy and the third sector, including the European Climate Foundation. She's also had the honour of supervising some of the most troublesome PhD students that have ever graced the halls of Queen's University Belfast. So we will then be joined after our speakers for a panel session by James Orr, Director of Friends of the Earth NI, Laura Neal, Solicitor for Friends of the Earth Ireland, Northern Ireland and the UK, and a key member of the drafting team for the Northern Ireland Climate Bill. Emeritus Professor John Sweeney from Maynooth University, who's extensive experience undertaking climate change research in Ireland and internationally, and Dr. Thomas Munzer, who is lecturer in energy transition law at the University of Aberdeen and who's co-director of the Aberdeen University Centre for Energy Law. So I'll now hand over to my colleague Matthew Mollihan from Climate Case Ireland, who will facilitate today's discussion. Thank you very much.
Thanks so much, Ciara. As Ciara said, there's going to be a Q&A at the end of the session. So if anyone has any questions they'd like to ask, please put them in the chat box. And maybe just say who the question's for at the beginning of the question, so the speaker's name. And now we're going to hear from Anurag, who's going to speak on the Northern Ireland Climate Bill.
Thanks very much. Hi, everyone. My name is Anurag Deb, and I co-drafted the Climate Change Bill Northern Ireland that was presented to the Assembly. It had its first reading in March, and I'm actually just going to put a link to that in the chat, so you can have a read of it at your leisure. It's a pretty short bill, 17 clauses, and 2 schedules. So please have a read of it, see what you think. I'm just going to do a very short presentation on the backdrop to this bill and its various provisions, why it came about, and the sort of thinking that goes behind it. So I'm going to try and share my screen. Okay, I can't share my screen. Oh, okay, I can share my screen. Right. Can everyone see that? Yeah. Okay, great. So, okay, so the climate change bill, first of all, this is a civil society effort. The lead sponsor of this bill in the Northern Ireland Assembly is Claire Bailey, the leader of the Green Party in Northern Ireland. And it is a bill which, amazingly, has pretty broad cross-party support, which is unusual for anybody who's familiar with the politics of the jurisdiction. But it has broad-based cross-party support in its passage. So delighted with that. So the background to this originally, of course, began with Brexit, and the fact that for so long we've been subject to environmental laws and decision making at the EU level, and indeed at the sort of Westminster level, concomitant with EU law and EU principles. And so a lot of the laws relating to climate change, relating to environmental protections that we've been subject to over the past few decades, we've simply transposed into our own law or implemented from EU decision making. But obviously that brings up a number of problems when you're considering Brexit, even with the operation of the Northern Ireland Protocol, which safeguards a lot of those laws for us specifically, if not for the rest of the UK. So this is a means of trying to enshrine a legislative framework for Northern Ireland going forward to try and decarbonize the economy, independent of the laws and decision making which might continue to happen as a result of the Brexit process. So it is a step in trying to Brexit proof, in a way, the attempt at decarbonizing Northern Ireland. So the priorities for this bill actually began with the New Decade, New Approach deal, under which the Stormont executive returned in January 2020. And in the program for government, in that deal, you have the imperatives to reduce carbon emissions in light of the Paris Climate Change Accord, the transition to a zero carbon economy, and a direct mandate to introduce a Climate Change Act to give environmental targets a strong legal underpinning, as well as a Green New Deal. There are aspects of this in the various provisions of the bill, and I'll talk about that as well. And finally, there are, of course, a number of concerns arising out of the fact that we share a border. Sorry, I'm just going to admit. Oh, sorry. Okay, hopefully that goes away now. So the border that we share with the South is a live concern, obviously, because there are a number of transboundary impacts that happen, both because of activities that we engage in that has an impact in the South, activities that are happening across the border that has an impact on us. And that hitherto has been dealt with by way of certain EU legislation or EU-derived legislation, like the EIA directive, for example, or the EIA regulations 2017, where there is a duty on the Department for Agriculture, Environment and Rural Affairs to communicate transboundary impacts to the other side, and so on and so forth. But we wanted to make sure that the transboundary impact on the climate here and on the environment here is enshrined in primary legislation in the Assembly. Okay, so the overview of the bill, there are three parts mainly. The first part creates a specific climate emergency mandate with a 2045 net zero target and climate action plans to achieve this target. The 2045 net zero target lists 7 greenhouse gases. The 7th one, nitrogen trifluoride, is one that I know there are efforts ongoing to try and get that into a UK-wide basis. With the environment bill that's going through the Westminster Parliament at the minute. So it's definitely one that so far hasn't really been on the legislative radar, but is trying to get there. Climate action plans are the policy prerogatives that the executive have to come up with and gain the support of the Assembly, which then implement the ways in which we can decarbonize the economy and the ways in which we can achieve net zero by 2045. that 2045 target is flexible, so it can be brought forward, but it can't be pushed back beyond 2045. The second part establishes the NI Climate Commissioner as an independent monitoring and enforcement body supported by the NI Climate Office. Effectively, and I'll go into more detail about the Climate Commissioner in another slide, but this is the oversight / auditing mechanism into the effectiveness of the climate action plans and the effectiveness of the act itself. So the Climate Commissioner has two main functions under this act. And the final part, part 3, contains supplementary matters, including a non-aggression principle. I'll go into a little bit more detail about what the non-aggression principle means in the bill and in the context of sort of coming out of the main orbit of EU law. Okay, so the general thinking behind the way we frame this legislation is that it speaks to general principles. It's not too prescriptive. I mean, there's examples of legislation that focuses more on the way to an outcome rather than an actual outcome. So, for example, the Offence Against a Person Act of 1861 prescribes maximum sentences, but not typical sentences. Those are subject to discretion at the judicial level, sentencing guidelines, and so on and so forth. There are two main reasons for this. Generally, outcomes should depend on the government of the day. Now, obviously, we want a strong and robust climate change mitigation regime, but we live in a democracy, and there is a level of flexibility that goes with that. There's a level of flexibility that goes with day-to-day governing and politics. That is a reality we have to recognize, and it's important to recognize that, because otherwise, you know, if you tie the hands of democratically elected governments, then what's the point of having democratically elected governments at all? So legislation that is too prescriptive may be a bit of a headache going forward if you have to keep coming back to the Assembly to amend those prescriptive targets every single time you need to change. And because while the science of climate change in terms of its anthropocentric nature has been well established, it is a bit of a fluctuating thing in terms of the kind of technologies that keep arising, the kind of targets that we need to hit. We need to be able to respond to the climate crisis as it unfolds, rather than having to keep going back to the Assembly to keep changing targets that are too prescriptive. So the Climate Action Plan, which is the central sort of premise of Part 1 of the Act, is a wide-ranging and precise plan which sets targets and goals as well as measures intended to achieve them. It sets interim targets going towards the 2045 net zero target. It's drafted by agreement within the executive. The nodal agency for the Climate Action Plan is the Executive Office, which is the First and Deputy First Ministers. But because this is such a cross-cutting measure, because it impacts the entire economy, sectors like housing, infrastructure, energy, agriculture, it has to be drafted within the executive by agreement within the executive, and it's presented for approval by the Assembly. So this locks in a pretty public, transparent, democratic process to adopt the plan. It's not simply a government plan, it is a plan presented by the executive for approval by the Assembly. And until it's approved, it's not going to be implemented. Wide-ranging consultation with relevant experts, bodies, including the Climate Change Committee at the UK level. There are also two other expert bodies listed within the bill. One is the IPCC and the other one is the Climate Advisory Council in the South. The duty to consult, the duty to obtain information is only on the UK Committee on Climate Change, simply because that committee has a legislative duty in any event under the Climate Change Act 2008 to assist devolved administrations in anything that they wish to do. Whereas obviously we can't create such a duty on bodies that don't have any presence in Northern Ireland or in the UK. So we can't create a similar duty for the CAC in the south, or indeed the IPCC. So the requirements that a climate action plan has to achieve, especially from an economic and infrastructure perspective, mean that departments like the Department for Infrastructure and the Agriculture and Environment and Rural Affairs Department have specific powers to make rules, one of which is on carbon budgeting, which DAERA has a duty under the bill to come up with a carbon budgeting mechanism, and to designate a department or designate a body to manage that mechanism. The Climate Commissioner is proposed as a completely independent body capable of two main functions. The first is the monitoring of the implementation and effectiveness of the Climate Action Plan. So a Climate Action Plan has a shelf life of 5 years. The first one will have a shelf life of 3 years. And each year of the plan, the Climate Commissioner will present into the Assembly a report of its effectiveness, whether the targets are being met, what is the likelihood of the plan getting implemented, what is the likelihood of the measures being implemented in time, what is the likelihood that everything combined can lead to the overall 2045 net zero target. And these are important because the Climate Commissioner's independence ensures that when the Assembly is scrutinizing the work of the executive to decarbonize the economy, it can rely on an independent source of review, of audit, of advice. And the second function is monitoring the effectiveness of the bill itself. So the Climate Commissioner will be able to recommend changes to the bill, amendments at the Assembly level, changes to practice between the various institutions to try and make the bill more effective, to try and make the climate change mitigation mechanism more effective. So it's an example of sort of post-enactment legislative review, which is somewhat unusual in many common law jurisdictions, but it's not that unusual here because this is a model that has been used, for example, in the Commissioner for Older People in Northern Ireland. So we do have independent bodies that keep suggesting improvements to their own parent legislation. So the non-regression principle is another highlight of the bill. It tries as far as possible to maintain the climate and environmental protections which existed at the end of the transition period under the withdrawal agreement. Now, obviously, under the protocol, we continue to be governed by a suite of EU laws, but not the entirety of the environmental protections and climate change related laws of the EU. It's only what is contained in the protocol. But more importantly, I suppose, there's no guarantee that we will keep a pace with the changes at EU law that are made at Brussels, ostensibly because there is a mechanism under the Withdrawal Agreement Act and under the Withdrawal Act of 2018 that means that it's Westminster and Whitehall that gets to decide how retained EU law applies on the UK-wide level as opposed to Stormont. But this is a principle of statutory interpretation rather than binding ministers or binding the Assembly. And it's highly similar to the Human Rights Act and its Section 3 duty to interpret as far as possible any legislation passed at any time in accordance with the Convention rights. So it's really something for the courts, something for public authorities to interpret legislation. And so the climate change bill needed to be clear, consistent, cogent, and certain, but also sufficiently detailed as to be effective. It was a framework, it is a framework, but it's not a framework that is entirely hollow. It has strong independent oversight, strong democratic checks and accountabilities built in, but also recognizes that there has to be a degree of flexibility. We need to be able to depend, rightly or wrongly, on the politics of the jurisdiction and the politics of the government of the day in order to ensure that we can effectively decarbonize the economy. So that concludes my presentation, and I just gonna return. So I look forward to any questions you might have at the end. Thank you very much.
Thank you, Anurag. That was brilliant. And we're now going to pass it over to Andrew Jackson, who's going to talk a bit about the climate bill in the Republic of Ireland.
Thanks, Matthew. Thanks, Anurag. That was very interesting. Could somebody give me permission to share my screen, please? So I'm going to say a brief few words about Ireland's Climate Bill 2021. And for anyone who hasn't been following the process closely, this is a proposed amendment, of course, to Ireland's Climate Act 2015, which was our first generation national framework climate law. So this is a second generation revision, an improvement of that earlier legislation. By way of overall summary of what's being done, clearly this revised iteration of the climate bill is a major improvement over the draft bill that was published late last year, and the changes will represent a major improvement to the Climate Act 2015 itself. And it's important to recognise that the pre-legislative scrutiny process that happened after publication of the draft bill by the Joint Oireachtas Committee on Climate Action, hearing from expert witnesses and so on, was really pivotal to this process of improvement that we've seen between the draft bill and the revised bill. And in overall summary, and many have said this, my point at the bottom here, the changes proposed represent a major improvement. The targets set are very challenging, but clearly the current level of ambition is not yet enough. And that's the first theme that I want to touch on. There's a lot that could be said about the Climate Bill and the Climate Act, indeed, as a whole. I'm really just focusing on some big picture points today, but very happy to speak about any further detail during the discussion afterwards. But first, for those who are unfamiliar with the Act and the bill, what does the bill do overall? And I picked out a few edited highlights here, focusing mainly on the mitigation side. I haven't really looked at what the bill will do as regards adaptation. So the bill introduces a net zero target that is to be achieved by 2050 at the latest, so a later date than Northern Ireland's legislation that Anurag just discussed. The bill, in a sense, emulates the UK Climate Change Act in introducing a concept that was missing from the Climate Act 2015 5-year carbon budgets, and within those sectoral emissions ceilings, which are effectively sectoral targets. Now, these 5-year budgets are to be proposed by the Climate Change Advisory Council in programmes of 3, so covering 15 years, and proposed by the Advisory Council and then to be adopted by government. The government can differ from the budget that is proposed ultimately, but has to give reasons for doing so. The sectoral emission ceilings, in contrast, are on the government side, decided by the minister. There is sort of a 2030 target introduced into the Act by way of the revised bill on the recommendation of the Joint Oireachtas Committee. And I'll return to that shortly and describe why I say sort of. It's not a numeric target set down in law, rather it's an instruction to the Advisory Council regarding what its first 2 5-year budget proposals are to look like. In terms of the sort of governance framework, the bill makes some changes to the Climate Act 2015. We're now to have a national climate action plan subject to annual revision. And that is working off the basis of the 2019 Climate Action Plan proposed, of course, by the previous government. So that's our starting point, in other words, for these annual revisions. There's also to be a long-term national strategy, looking, of course, at the longer term to 2050, and that is to be revised at least every 5 years. That is the planning document to which the Supreme Court's judgment in Climate Case Ireland attaches now. So the requirement to provide a sufficient level of specificity as to how the government proposes to achieve net zero by 2050, that obligation now attaches to the long-term strategy, previously attached, of course, to the National Mitigation Plan. The bill also provides for local authority climate action plans to be prepared at least every 5 years. And it provides for a strengthened role for the Advisory Council and greater diversity in the Council, because up to this point, of course, the Council has been dominated by male economists. The bill provides for greater diversity going forward. If we look then, I wanted to look at 3 things: the overall ambition of the bill, the near-term ambition, and then accountability. These are some big picture points, but I think they're very important that we bear these points in mind, because there's of course a tendency to get down to the real detail and to debate what's being done by the bill. But let's for a moment take a step back and say, first, of course, net zero by 2050 is too late for Ireland on the basis of equity. And a suggestion here would be to give the Advisory Council a specific duty to advise very regularly. And by that, I don't mean annually, I mean more like monthly. We see nightly briefings from NEFIT in Dublin in the context of COVID. We should have very regular advice from the Advisory Council on whether our targets and our ultimate decarbonisation year are still appropriate with reference to the Paris Agreement's concepts of progression and the highest possible ambition. And a related point, of course, is that the net in net zero does a lot of work in the sense that it assumes very large scale negative emissions for which we have no plan. And that is, of course, a major issue that needs to be borne in mind. Our near-term 2030 commitment is not ambitious enough. The programme for government commitment, which you'll know was this these linked concepts of a 7% per annum average reduction over the decade to 2030, amounting to minus 51% when you compare annual emissions in the baseline year of 2018 and annual emissions in 2030. If delivered, that would amount to about a 46% reduction, comparing using the traditional baseline from the UN Framework Convention of 1990. So minus 46% comparing 1990 emissions versus annual emissions in 2030. If we look to the EU's own target over the same period, minus 55%, as you'll all know, and that is in itself insufficient to comply with the Paris Agreement. So in other words, we're proposing to contribute below the EU average to what is an insufficient EU goal. Also important to recognise, because there's been some commentary that I've seen saying that we're enshrining in law the most ambitious target over the next decade. Important to say that that is not the case. For example, Denmark has enshrined minus 70% between 1990 and 2030 in law, meaning that from a standing start today over the next decade, they're going to be doing more than the programme for government commitment over the next decade. And the reason I say that is not, not just to say there's somebody out there who's doing something better, is because if we have the message out there that we are being the most ambitious in the world, it's a very short step from that to saying, well, yes, we're off course, but of course we are because we set such an ambitious target. In terms of other countries and relative ambition, The UK, of course, last week moved its target to minus 70% or 78% reduction in CO2 emissions between 1990 and 2035. So a slightly different finishing point there. So our near-term commitment is not ambitious enough. Our long-term commitment is not ambitious enough. The bill is silent on how Ireland will treat international aviation and shipping. In other words, we do not propose to include those emissions within our carbon budgets. And that is in contrast again to the United Kingdom, which last week said from this point forward, it will include its share of international aviation and shipping emissions within its carbon budgets. That's a big issue, of course. The bill is silent on the importation of LNG, fracked gas, silent on the building of LNG terminals. The government has said it's going to bring forward a policy statement on these matters in the next few weeks and months. The bill is silent on the promised ban on future exploration licenses for fossil fuels, which the government had said would be in the bill, but has not materialized in the bill. And overall, the bill is weak on climate justice and just transition, which are sort of have regard to matters in the bill. Now, near-term ambition for 2030 then is really vital. You know, it's really so important what we do in the next 10 years. It will set the course for what follows, and also will, you know, determine whether it's possible for us to stick to carbon budgets that are consistent with meeting the temperature limits of the Paris Agreement and so on. So the Programme for Government Commitment I mentioned already has these linked concepts of 7% per annum reduction in overall greenhouse gas emissions between over the decade, amounting to this 51% reduction, comparing annual emissions at the start and annual emissions at the end. And one thing that John Sweeney, who's here today, and myself and Barry McMullen have pointed out, we wrote to the government recently about this, we feel that the bill does not faithfully deliver this Programme for Government Commitment to 2030. And I won't go into the detail of the language, but I'll try to explain the problem by way of an image on the next slide. And before doing that, I'd simply say, however this 2030 commitment ends up being framed in the bill, it should of course be possible for the Advisory Council to propose a smaller budget than the Programme for Government implies. And that would tally with the Joint Oireachtas Committee's request for a minimum interim target for 2030. Now, the problem that we identify with the way the bill proposes to introduce the 2030 target is, so the bill essentially says to the Advisory Council, we want you, my second bullet here, we want you to propose for the first two carbon budgets a particular thing. Now, the first problem is the language is very unclear as to what is being asked of the Advisory Council, and that could of course immediately lead to litigation over the Advisory Council's first budget proposals. But the most likely, what we believe to be the most likely interpretation of the language is as follows, and it differs from the Programme for Government Commitment, because what it seems that the bill may be asking the Advisory Council to do is to propose a budget that is predicated on annual emissions in 2030 being 51% lower than annual emissions in 2018, which is the baseline year. But the bill has dropped the linked concept of the 7% per annum average reduction. And you need both of those ideas to give you the pathway and the carbon budget implied by the Programme for Government Commitment. By simply specifying a reduction based on annual emissions at the start of the period and annual emissions at the end, what that allows for is the Advisory Council to, for example, propose any of the pathways shown on the slide here. So, for example, it would be notionally consistent with what the bill seems to provide, for emissions to be allowed to flatline out to 2029, and then for us to have this cliff edge reduction in the final year, which of course is not realistic at all. But by dropping the 7% per annum average language from the bill, we argue that the bill doesn't faithfully transpose the Programme for Government Commitment and allows the Advisory Council to propose, carbon budgets that are much higher than are implied by the Programme for Government Commitment, and that is a big problem that needs to be fixed, I think.
Andrew, we're just coming up on time here a little bit now. So.
Sure, sorry, Matthew. My final point is accountability. Thanks. And two things to say here. What happens in the event that carbon budget is exceeded? What the bill proposes is that the next budget would be reduced by the amount of the exceedance, which passes the buck to the next government, passes a potentially unachievably small budget to the next government. So maybe what's needed here is a much stronger legal duty requiring the government as a whole, and not just a minister, to stick to carbon budgets. And my final point is this interesting provision from the bill, which purports to limit the government's liability in compensation or damage resulting from any failure to comply with a provision under the Climate Act. Sharon is about to speak is very strong on the idea of the importance of accountability in court to a climate governance system, because it shouldn't just be viewed as an adversarial thing in which the government doesn't want to be held accountable, because rather accountability in court can provide, for example, political cover for climate action in circumstances where a government is being told by the court that this is what you need to do to comply with your legal obligations. So this idea of limiting liability runs counter to that and reduces accountability. And the fundamental problem I see with this is, under the European Convention on Human Rights Act, damages is one of the central remedies for an infringement of human rights. So is this limitation of liability provision lawful full stop? Will we be providing an effective remedy for an infringement of rights if we have this limitation of liability clause? And who should be concerned in practice? Well, for example, people living in the hundreds of square kilometres of Ireland that the EPA has said may be impacted by sea level rise and storm surges, people whose right to life may be negatively impacted, people whose right to respect for private and family life and home, and similarly, people living in the path of future storms, which of course is all of us. I'll stop there. Thank you very much.
Thanks so much, Andrew. Next, we're going to pass it over to Sharon Turvey, who's going to talk about the EU climate law.
Thanks a lot, Matthew. Well, it's first of all lovely to be here this morning to be able to join the webinar and to meet again with lots of old friends and allies. So thank you very much for the invitation to join you. The European climate law, which is the subject of my presentation, is literally hot off the press, and indeed it's so hot off the press that we don't actually know, we don't actually have the final text available yet. So we're not entirely sure what's in it. I haven't prepared slides, so apologies about that, but I hope I'll be able to talk you clearly enough through what we do know about what's there. For my part, I've been working towards a European climate law, I suppose, in the years since I left the academic world in 2012, so it's been quite a long time in cooking. I've been mainly doing this work with the European Climate Foundation, but it was a very intensive push on the part of the foundation and all of its partners across Europe and many, many others, of course. Once Ursula von der Leyen announced the European Green Deal and that there would be a climate law proposed as part of this. And in the time that we have available this morning, I'm going to try to focus mainly on what we think has been included in the text rather than what's been excluded, because it has been an intensely fought battle between the European Parliament on the one hand and the Commission and Council on the other side. And I suppose, sadly, whereas we would normally have been able to rely on the Commission to be an ally on environmental and climate measures, this time I think the Commission has chosen to be very conservative in what it wanted to propose and indeed what it wanted to support in the final trilogues. But in essence, in terms of the actual structure of the legislation, it very much follows the pattern of best practice occurring across many countries. I mean, even listening to Anurag and Andrew's earlier presentations, the essential structure is very, very similar, although with differences because of the kind of, I suppose, multi-level and multilateral nature of the EU. But essentially, the legislation has followed two core paradigms in design. One is to commit to a long-term climate target that is binding and aligned to Paris. And secondly, it has created a binding framework designed to ensure that that target is achieved. And in that respect, it's following the UK model, France, Ireland, Sweden, Austria, Finland, now Northern Ireland, and many others. Most of the media coverage about the legislation has focused very much on the 2030 target, which I'll come to in a few moments. But I think that there's been a lot of negative coverage of the legislation because of dissatisfaction with the ambition in the 2050 or the 2030 target. But I think it's important in many ways not to overlook the importance of the strides that are being made in the governance framework at EU level, because I do think important steps forward have been taken, although there's still a lot of work to be done in the next year or two. The Commission's proposal on the governance framework was extremely minimalist when it was first proposed, and the Commission made a lot of mileage on the need to avoid this kind of monster legislation, and it was just supposed to be symbolic. But we have worked very closely with the European Parliament to develop a much more coherent conception of what is a meaningful framework for transparent, accountable, and scientifically informed climate governance. And that, I suppose, has been the major focus of the work that we have done. And I think this governance framework has been incredibly important for 3 or 4 reasons. First and foremost, it has been crucially important to get the EU to move away from a totally short-term incremental approach to climate policy. This is the first time now that the EU will have committed to a binding long-term climate target that is aligned explicitly to the Paris Agreement and to the Paris objectives. So the EU is finally signalling seriousness about implementing Paris. The framework, I think, is also important because it starts to take decision-making on climate policy and climate target setting out of the realms of totally political deal-making behind closed doors into a more transparent, science-based and accountable and predictable process. And I think that is incredibly important. It also creates a framework, an explicit framework for policy backcasting from a defined and scientifically informed long-term target, so that there is at least a duty on the EU and on member states to develop climate policy in a manner that's consistent with achieving the long-term target. And I think that backcasting process will also function to move the EU away from this extremely incremental approach to climate policy development. And I think the other general point to make before going into the details is that the climate law, the European climate law, should also be seen in connection with the very important developments going on in parallel under the Aarhus regulation. There is an intense battle going on at the moment between the European Parliament, the Council and the Commission about the revision of the Aarhus regulation, which, if it is successful in terms of our ambitions, it will give NGOs and hopefully citizens for the first time meaningful rights to challenge EU decision-making and Commission action on climate before European courts, which I think would be an enormous breakthrough in terms of accountability. But in terms of the more specific contents of the climate law, I think the kind of key things to flag are, obviously, first and foremost, there's been 2 targets have been established in law. One is the 2050 target, defined essentially as the EU is committing to achieve climate neutrality by 2050 at the latest. There is also a commitment on climate resilience, but I don't have the exact text on that yet. The European Parliament wanted the 2050 target not only to be collective, they wanted it also to apply to each member state, because there are several countries that have not adopted their own national climate acts and committed to a 2050 target. But the Council, with the Commission, didn't propose this, and the Council wouldn't agree to it, which is very worrying. And the Parliament also wanted a target for negative emissions, which was also rejected. So I think that is also a worrying sign in this. The climate law will also commit to raise the European Union's climate target for 2030 from the 48% agreed in 2018 to what is being defined as at least 55% net and potentially to 57% net. And I think just given the time available, I won't go into the details on this. I mean, many of you will have been following this very closely, but I'm very happy to answer questions on this in due course. But there has definitely been a lot of dissatisfaction about the Commission and Council's unwillingness to come to a much more credible compromise with the European Parliament about emission reduction targets for 2030 that are anything like what is credible to keep the 1.5 degree pathway alive within the EU. But in terms of the governance framework itself, I think an important win for the European Parliament has been that it has succeeded in winning provisions requiring the EU to set up what is defined as a European Independent Scientific Advisory Board on Climate Change. This was not proposed by the Commission. It was hotly resisted by the Commission, tooth and nail, right down to the bitter end. And I think this really shows the Commission's resistance to accountability, but also the Commission's realization that this body has the potential to hold the Commission itself to account for the quality of its own policy proposals. The main task of this body will be to provide scientific advice to the EU institutions and to issue independent reports on existing and proposed European measures, European targets, and its indicative greenhouse gas budget, and also to evaluate their coherence with the EU achieving its 2050 duty. And even though independent is in the title, I think it remains to be seen how well the independence of this body will be protected, because the membership of the body is going to be appointed by the Management Board of the European Environment Agency, which of course includes the Commission and several member states. But most of the national advisory bodies are also government appointments, so I think that's part of the normal process. But I think there'll be a lot of scrutiny about the quality of independence in terms of the experts appointed here. It's also, I think, just very important to emphasize that it's been very significant that the European Parliament managed to hold on to an explicit mandate for this body to evaluate the coherence of European policy and targets with achieving the 2050 duty, because that was the core issue the Commission wanted to resist. It did not want to have an independent body commenting on the quality of policy making at European level. And I think that is a very significant step forward, given that, excuse me, these bodies have played an important role in several countries in terms of forcing on a more ambitious dialogue and giving political cover for more ambitious targets and action. It also remains to be seen when we get the final text to see if the sentences in the provision have survived, basically inviting individual countries who have not already done so to also create similar bodies at national level. The Parliament had wanted more strenuous language, basically urging or even obliging in an earlier draft countries to do this, but we'll get the final text later this week and see what's in there about the national level. I think the other big governance feature in the European climate law is that the Commission is empowered to do a consistency check of European and member state policies to check their consistency with achieving the European 2050 target. And this really is, I think, going to be the acid test of the European climate law, because the climate law will only be a success if it has a material impact on the quality of policy consistency with the 2050 duty. And I can speak in more detail about how this is going to work, but just very briefly, There are two elements of it. From now on, every time the European Commission wants to bring forward any draft measure or draft policy in any sector of European lawmaking or policy making, there has to be an initial assessment of its consistency with achieving the Union's 2050 climate duty. And that will have to be factored into the impact assessment of the measure. So it's kind of a form of climate mainstreaming. And secondly, the Commission is going to be empowered to undertake a 5-yearly review assessing collective EU and member state progress towards delivering the 2050 objective, but also a consistency check of member state climate policies and EU climate policies with the 2050 objective. And if the Commission finds that there is either an inconsistency at national level or at EU level, the Commission is obliged to take action. At member state level, it issues recommendations. These are non-binding. There was a huge tussle between the Parliament and the Commission and Council about closing down the legal language, making it as hard as possible for member states to resist recommendations, but we don't have that final language yet. But ultimately, from a lawyer's point of view, it isn't going to be a binding obligation on the member state to comply with the recommendation, but it is at least putting an additional pressure on member states to take policy consistency seriously. At the European level, if there is an inconsistency identified, the Commission is obliged to bring forward remedying policy proposals. There was also a lot of hope within the European Parliament ranks and our own ranks that we would get rules setting down a deadline for the phasing out of fossil fuel subsidies. The compromise has been quite weak, but I think it is still an important step forward. There is going to be an amendment in the EU governance regulation that requires the Commission to further clarify and define the methodology that it's going to use to monitor how member states are moving towards the phasing out of energy subsidies and particularly fossil fuel subsidies. At the moment, there's no common methodology, so everybody's doing their own thing in terms of their reporting to the Commission. And not surprisingly, we've discovered that member states are also largely underestimating the amount of fossil fuel subsidies they're actually reporting. So while there's still no deadline to phase out fossil fuel subsidies, at least this technical amendment will make the process, the scale of subsidies, more transparent, and will put more pressure, I think, on the Commission and on member states to take action on this crucial issue. There is also going to be a new framework for setting the EU's 2040 target. It's a kind of a multi-pronged process. On the one hand, within 6 months of the first global stocktake in, I think, May 2024, the Commission is going to be required to publish a legislative proposal setting out proposals for the 2040 target for the EU. Alongside that, the Commission is going to also have to publish what is described as a separate and indicative EU greenhouse gas budget spanning the 20 years from 2030 to 2050. That budget is defined as the indicative volume of net greenhouse gas emissions that are expected to be emitted in that 20 years without putting at risk the EU's commitment under Paris. Now, there's a lot of uncertainty about what this really means in reality, but what we do know is that the climate law will require the budget to be set according to certain criteria. Those criteria include best available science. So the budget will function, I suppose, as a transparency mechanism, which is designed to clarify at a political level and at a governance level the remaining budget that Europe has, and it will provide a sort of, I hope, a political sense check on the need for an ambitious 2040 budget or 2040 target. But that said, it is not going to prevent the Commission from proposing a weak 2040 budget if it is minded to doing so. But the governance framework is designed to set up and force greater and greater transparency about the scientific implications of the choices that are being made and that are ahead of the EU. So I
suppose
suppose
coming up on time here now, Sharon. Thanks.
Sorry?
We're just coming up on time, so if you just have another minute or two to wrap up, that'd be great. Thank you.
So I think just to wrap up very quickly, it's basically, I think there is optimism, I think, within the European Parliament. We had a download this morning from some of the MEPs and with our own partners. There is, despite the frustration on the 2050 target or the 2030 target, there is, I think, a sense of optimism that the governance framework will create this pressure on transparency, depoliticizing policy making, foregrounding science. But there is also a recognition that the climate law is very much about governance at EU level and says very little, if anything at all, about governance at national level. We now know that while numerous countries have gone forward unilaterally and developed very strong national climate laws, and like Ireland are amending them to make them stronger, the European climate law is going to be implemented into a highly divergent landscape across the EU, with highly divergent preparedness for policy making that is consistent with the 2050 target. And that is where I think we are now turning our attention to calling on the Commission to reopening the governance regulation, the EU governance regulation, so that we can level up the quality of national climate governance and law across all member states. I mean, I'm very happy to take questions on that in more detail, and that's a project that myself and Tom Unser, who's on the panel, are going to be moving on to address in much more detail. So I suppose it is an important step forward for Europe, but a lot more work yet to be done. But thank you very much.
That's brilliant. Thank you so much, Sharon. We're just going to move over to the Q&A now, but just to say that we are coming up on 1 o'clock. So if any of the panelists need to leave at this time, that's okay. But if any of our guests want to continue to add questions into the chat box, we'll be sure to put them to the panelists once they stay. And also to say that we're kind of hoping to make this a continuous conversation. So any questions which don't get answered today, hopefully we can answer them in a later session. Just to start off, someone asked earlier on, will Andrew's slides be available at the end of this presentation? And both Anurag's and Andrew's will be available. We'll have a link once the presentation is finished. So then just the first question to our panelists would be from Kira. She asked, can I ask whether the panel is aware of any cross-border discussions about alignment between targets across the island? And if not, should there have been? So if one of our panelists want to take that question on. No takers. Maybe James, do you want to take it?
Yeah, certainly in the New Decade New Approach Agreement, you know, which established a requirement for a Climate Act, there was an absolute stated position that we should be cooperating on the island of Ireland on this, you know, and if we can ensure this free movement of goods and services, we could equally stop the free movement of atmospheric pollution. But this is a massive issue of political governance here, isn't it? And we need to really think this through. But in terms of mechanisms that need to be put in place, absolutely, from a policy and advocacy point of view, we would totally advocate for that. I don't see the mechanisms that are instantly available, you know, with the transitions around Brexit and other political realities at the minute. It's a very complex area, but yeah, we need to rethink this, and we need to develop mechanisms that work.
Thank you. Let me see now. So Melina Sharp is after asking about the loopholes exposed in the Shannon LNG PCI list case, which shows the government does not have regard for climate mitigation and reduced greenhouse gases. She's asking, is that loophole still in the current climate bill?
I can say something about that. Yes, it is, because that issue arose as a result of a High Court judgment after the revised text was published. But I'd be hopeful that that might be a government amendment proposed at committee stage. The issue, for anyone who's not familiar, is that this High Court judgment looked at section 15 of the Act, which imposes general duties on public bodies, and said, well, the government as such is not covered as one of the relevant bodies subject to these general duties. And where the Act gives a duty only to a minister of the government, that doesn't also capture the government as a whole. So clearly that's problematic and ought to be picked up.
Okay, brilliant, thank you. So we've one question here for Sharon. Naomi wants to know, what was the reason behind the Commission's resistance to the new Advisory Council?
Well, it's a good question, and it's difficult to provide an absolute answer. I think that in the very beginning, the Commission's objection was focused on the argument that the creation of an expert body, as we were describing it, and the Parliament was describing it, would be an overlap, a kind of a duplication with the IPCC. And after many webinars and presentations and all the rest, the Commission was finally persuaded that the IPCC has a global function but does not translate its climate science into individual geographies, and that there was a need, therefore, to have an independent expert body for the EU commenting on and evaluating on the quality of policy making you need to make sure that the EU itself delivered on its Paris commitment. Then the Commission turned its attention to arguing in favour of a scientific body as opposed to an expert body. The Commission then spent several weeks and months lobbying to turn the body into a scientific body that would advise the EEA, the European Environment Agency. And the effect of that would have been to turn the body away from the policy context. The Commission was basically trying to create a body that would have no power or mandate to comment on the Commission's own work in developing proposals for climate policies or setting climate targets. And that, I think, signaled to me, at least speaking purely personally, but I think many colleagues would agree, that the Commission essentially did not want to have another entity that had a formal mandate within the European institutional community to comment on the quality of target setting and policy making at EU level. And I think it's tremendous credit to the European Parliament that they held firm, and despite the shortcomings in the final provision, that this body now actually has this mandate to comment on the quality of policy making and target setting. So I think that, I mean, in a sense, my response is essentially what I have observed from the way the Commission has responded to this. But several countries, several of the Council members acknowledged that these national bodies have played a very important role in improving the quality of climate governance at national level, and they were very much supportive of having one at European level, essentially to depoliticize policy making.
Brilliant, thank you. I'm just wondering, before we go to a different question, does Thomas have anything to add to that?
Pardon?
I'm sorry, I'm just wondering if you have anything to add to that question about the reluctance for the, sorry, let me reread the question here, please.
No, I'll stick with Sharon's answer because my connection partly broke up when she was responding, so I don't want to reiterate, although I do have views on that. I don't want to reiterate what she said. Thanks. Okay,
that's no problem. Thank you. Let me see. So Michelle Hanrahan has asked a question, and she's wondering, are there any organisations similar to Climate Case Ireland across the EU that are doing similar work that we're doing? So I don't know if anyone, maybe Andrew wants to answer, or if anyone else has an answer for that.
Maybe I think Sharon maybe is better placed in terms of the organisations at Brussels level, you know, operating in this area.
Well, I suppose the largest organisation, I think, litigating in terms of, do you mean on litigation? I presume that's the question it's about. The Client Earth, I think, would be the kind of the classic answer to this. They now have offices in several European countries, and they're also grant making themselves to smaller organisations in different countries. So I think that FILE is another litigation organisation that has been recently set up. I think they're headquartered in London, but they have an international reach. I'm sure there are others. If I think of them, I'll put them into the chat, but they're the two major ones in my mind.
That'll be brilliant. Thank you, Sharon. I just have a question here for John Sweeney. Rob is asking if he can shed light on how the proposed climate bill addresses banning single-use plastic, consumer goods packaging, and governing the fishing industry.
Well, I don't think it does, quite frankly. Plastic pollution is not seen as part of the remit at all in the climate bill. Similarly, the fishing problem is not really covered, and these issues have been carefully and scrupulously avoided in the designation of the climate bill. But in that context, I would say that the Northern Ireland bill actually handles many of these aspects in a rather more radical way. One of the most positive aspects excuse me, of the Northern Ireland bill is that it introduces the concept of nitrogen budgets. And this would have been a great asset to have in the bill in the Republic, where it would have brought in many vital aspects of consideration in relation in particular to agriculture, and conceivably to things like fish farming as well. So, I think that's a sad omission. While I have the floor, I wanted though to also ask Sharon in this sense, because one of the issues she raises there concerns national governance, and there has been some speculation that the pre-existing mechanisms of the effort sharing regulation might disappear as part of the new reform associated with the climate bill. And if that is the case, I was wondering, can she shed any light on what might replace an effort sharing regulation at national level and how it would be enforced at all?
Sorry, is that question to me?
Yeah, please. Yeah.
I actually lost connection at a critical moment in your. Would you mind just repeating essentially the question for me? Sorry.
Yes, I mean, in terms of national governance in implementation of the EU climate law, there has been some speculation recently that the effort sharing regulation approach might be abandoned in favour of something else. And I was wondering, could you throw any light on this? Because in its absence, it would be very difficult, I think, for national governments to actually deliver the goods if they haven't got any regulation behind them.
Yes, indeed. Well, I think to many people's consternation, the Commission's inception impact assessment posited the idea that they would expand the EU ETS into housing and transport, and potentially do away with the need for state-led action in those sectors, and possibly just get rid of the effort sharing regulation altogether and just expand the LULUCF. And there has been a very concerted pushback on that idea, certainly amongst the partners working in Brussels, ECF, Ecologic, Transport and the Environment, CANI. There are numerous partners have opposed this. And there has been a very, very strong argument to say that the state has a pivotal role to play in climate policy making. And that is very, very strongly reflected in the fact that irrespective of what Brussels is doing, so many countries are bringing forward their own climate legislation, making the state centrally responsible for developing climate policy. And I think the argument has been put very squarely to the Commission that while carbon pricing has a role and an important role to play, it does not mean squeezing out the role of the state, and that it would be very regressive to do so. And it would be particularly regressive to do so in the context of the pandemic, where it could be very easy for countries, for governments who are not particularly interested in climate, to say, actually, this is just all too difficult, or the EU is making us do it. So there has been, our understanding informally in terms of contact with Commission officials is that the Commission has now accepted that they will retain the effort sharing regulation. But I think there is still a question mark in our minds as to whether we should be calling on the Commission to review the effort sharing regulation, not just to simply be a 2030 mechanism, but to be a mechanism for placing 2030 into a longer term context. Now, I suppose your MEPs this morning were saying it's impossible given that the Commission and Council have just literally rejected that idea. So the best we can do is hope that the ESR stays and we just make it as ambitious and strong as possible. But I think that European governance is still in a state of extreme flux. And I think in the next 2 to 3 years, there'll be a lot more change.
Sorry, could I just comment just briefly just on the plastic bag point? It's a small issue in relation to Northern Ireland. National climate legislation had created the capacity to apply bag charges, national climate legislation, and that preceded the Northern Irish climate bill. And so that had already been received into the sub-state legal order and was operating. So in that sense, I don't think there was considered a need to roll that into a devolved climate bill as well for Northern Ireland. So that was already up and running, as it were, in that case. Thanks.
Brilliant, thanks. So we're at 1:10 now, so we just have one more question for Laura. And someone asked, what is the latest on the rival bill being developed by the Northern Ireland Department of Agriculture? Will that materialise, and how will that impact the private members bill?
As far as I'm aware, the rival bill is still in formulation stage. I haven't seen it yet. Maybe Anurag might be able to correct me if that's something that has changed. So as far as we're concerned, and as far as the coalition and the private members bill is concerned, we're still the only show in town. We're first in the door, essentially. So we essentially control the narrative of discussion. Our bill is quite strong compared to what we anticipate the rival departmental bill will be. So hopefully it can show up the flaws of the rival bill and engage in sort of a greater degree of discussion that we wouldn't have had without this private members bill taking precedence.
Thank you so much for that, Laura. Just as we're nearly at, Anurag, do you have anything to add to that?
No, just to echo Laura. I mean, I usually find it unhelpful to even think about a bill that I haven't seen, and I haven't seen it. I don't think anyone has. But you know, when it is presented, obviously we'll have that discussion. And from a point of principle, I think the more variation there is. This isn't the only way of doing things. Obviously, the more variation there is, the more discussion there is, the better it is. I mean, that's quite frankly the infrastructure of our bill. The better the discussion, the more the discussion, the better we can have an outcome that is acceptable to everyone and that is robust and that is strong. So I welcome, suggestions to the contrary.
Brilliant, thank you. Just as we're coming up on 1:15, I'm now going to hand over to Clodagh, my colleague at CCI, and she's just going to wrap up. So, Clodagh.
Thanks, Matthew. Just to say a very quick thank you to our fantastic speakers. We're honoured to have such an incredible array of speakers and panelists today offering their expertise, and we would really see this webinar as the beginning of a conversation, particularly as the bills in the Republic and Northern Ireland evolve over the coming months. We would love to have another one of these sessions to see how developments are happening. I'd like to give a special thanks to Ciara and Matthew for doing a fantastic job of facilitating, and for Orla Kelleher for her help in organising this event. And for anybody that wasn't able to access this event, this will be recorded. And if you're now watching the recording and you have questions for our panelists, please do send them to us. You can email them to info@climatecaseIreland.ie, and we will put together a briefing with Environmental Justice Network Ireland and Friends of the Earth Northern Ireland and make sure that we have all your questions answered. So thank you so much, everybody, for coming in. And thanks so much to the audience for getting involved in such a rich discussion and your really fantastic questions. Thank you, everybody.
Thanks.
Thank you.
Bye, everyone. Bye.
Thank you.
Thank you.